Then okay, understood. Okay, very on.
Court officer? Court officer?
Wait, sir.
Am I audible?
Sir, please wait.
One.
See the for posting for Monday, the company is under liquidation. The company is under liquidation. There's some urgency now.
After vacation. 1st of July.
Any mention?
Your Honor. Your Lordship, this is a contempt matter. In the final order passed by in the writ petition, the Honorable Court had directed for issuance of a revised demand notice for payment of property tax and to refund the access. Until date, the complainants have paid a sum of 12 crores. And as per the calculations, we are liable to pay only 2 crores. So there is an excess of 9 crores that's still with the BBMP, who's accused number 1. And that is a part of the working capital that the complainants are in dire need of, given the financial hardships that is facing right now. So if at all, it could be listed at 2:30 today
4th July.
or on Monday, Your Lordships.
4th July.
Any other mentions? Content matters. Still number 1, Mr. Ravi Kumar M.
For complainant, the issuing the 11E sketch, 2022 online application filed.
Yes, what do you?
That is,
Lords, the time is actually not stipulated, my lords. It
The
only
order-
says they are late.
Dated 25th July 2024, which is brought under the contempt jurisdiction for its direction to consider the, for its non-compliance direction to consider the online application of the petitioner, does not contain, as rightly submitted by, as is rightly submitted by learned additional advocate Srimati Kishan, the timeline within which the compliance is to be done by the authorities. In the circumstances, paragraph. The contempt petition at this stage is not maintainable since it is not possible to conclude that any of the respondents have committed contempt of court, much less willful contempt of the directions of learned. At the same time, Learned advocate for the petitioner submitted that the court at least may fix time limit for the compliance while not entertaining the petition on the aforesaid ground. Also, the request is reasonable. The petition is disposed of by directing the competent other respondent to comply with the directions of learned in the order dated 25th July 24 in writ petition number 19559/24 within 6 weeks from
please.
Still number 2,
2, 3, 4, 5 notice returnable on.
My lords, I'm appearing for the petitioner in this case, my lords.
Returnable on 4th August, 4th July. Yes.
My lords, serial number 2 to 5, kindly pass it over, my
6
lords.
also,
Number
6
6.
also notice returnable.
Time for the
Yes. Next.
complaints. In this case, my lordship.
7.
7,
Serial number 6 and 7. I am for the petitioner. Complaint. In this case, my lordship, at annexure A, this single judge of this honorable court was passed the order to consequent to the restoration of the grant in favor of the petitioner, the RTC shall also be entered in the name of the petitioners at annexure A, my lordship. May kindly look into that annexure A, operative portion.
But in which
number
serial
6.
number?
My lordship.
Serial number?
6.
6 is already over. 7. Call out 7.
7. 6 and 7, my
They
matter.
are not common. They are common.
Common matters.
Common. Right. 6. So 6 may no notice.
Serial number 6, my lordship. At annexure A, may kindly look into the operative portion, point number 6, consequent to the restorations of the grant in
The
favor of
operative
the
order
my lordship.
dated 28 March 24, passed by learned single judge while allowing the petition in part, reads as under. And page 16 of 2 to 6 to be reproduced. Full stop. While the aforesaid directions are brought under the contempt jurisdiction for their alleged non-compliance, it could be immediately seen that no time limit is prescribed by learned single judge for the compliance. Full stop. In the circumstances, it is not possible to conclude at this stage that any of the respondents have committed contempt of court, or much less a willful contempt. The petition and the contempt petition is not liable to be entertained at this stage. At the same time, since order the court should not go on comply with. Come on. Learned additional government advocate Srimati Pramodini Kishan stated that if the court prescribes time limit, the authorities will comply with the same within such time limit. First of in the circumstances and in the facts of the case, the present petition disposed of by directing competent authority respondents to comply with the directions, the aforementioned directions, within 8 weeks from today. The contempt petition. Same order in
Serial number 7. 7.
just
Similar.
change the operative portion and date of.
Great. Seal number 8, PA.
Lord, I appear for the petitioner, my lord. Is a public
No.
interest litigation filed by the villagers, my lord.
Notice returnable on
Lord,
23rd July.
my lord, in the meanwhile, my lord, the interim order, my lord, that the
No,
respondent, my lord, is trying to establish the, my lord, garbage unit, my lord, abutting to the my village, my lord.
Yes, next. No interim
Number
order, Mr. Counsel,
9.
at this stage.
I appear for the
Now, 9 is what is the proof of all this?
Pardon me.
What is the evidence for all these allegations?
Lord, there are, it's an admitted fact, my lord, that it has actually happened. There are news reports also, my lord, and there has been a lot of, my lord, media has reported, and there are complaints coming from all corners of the, my lord, state.
For the Yagno Babis were removed.
Yes, my lord, they were asked to be removed. Some of them had to remove it, but, my lord, it was cut and thrown.
Why?
My lord, there is no guideline for it.
No,
but,
why? What could be the reason? Nobody would do that.
my lord, the officers, my lord, who are manning the examination centers, they have insisted that it should not be worn. And my lord, the examination is conducted by the third respondent. The director of the third respondent says that the centers are manned by the local administration, which is under DC's control. Therefore, my lord, there is a blame game.
There must be several centers for examination.
Yes, my lord.
So it happened at every.
My lord, it happened. It is reported to have happened in many centers, my lord, but mainly, my lord, in Shumaga district and Dharwad and Bidar, my lord, which I have mentioned. 3 places, my lord. Para 7, my lord, page 8. Para 7 at page 8. These are bottom of that page, my lord. I have given 3 centers which are in different corners of the state.
If turns out to be correct, comma, the allegations in this public interest petition are prone, PRONE, to assume serious dimensions about the violation of cultural cum religious rights of the examinee students. The petition filed by Akhil Karnataka, filed by the society, petitioner society, don't mention name, alleges inter-alia that it is in 1994.
Yes, my lord.
Pardon me. Delay this much.
94 registered society.
No. Exam was held when?
No, 17-4.
That in the exam.
25.
Where is that date?
17-4 in the.
That in the examination conducted by the respondent authorities for medical, dental, Indian system, all these examinations.
Timetable is at page 24.
That examinations conducted on 17/4/20. On the occasion of the examination conducted on 17/4/2025 by the authorities, which was CET mathematics examination.
Yes, ma'am.
Comma. The students were ill-treated at various exam centers in the state of Karnataka, and that they were forcibly asked to remove what is described as inward comma, what is described as likhna hai, what is described as then inverted comma, Janivara, JNIVARA, which is also described as a sacred thread, THREAD, which is put on by the student as part of their cultural and religious and cultural practice. It was submitted by learned senior advocate, so and so, that the incidents happened at all the centers, in particular in Bidar district, in Shivamoga district, and in Dharwad district. Full stop. The averments in this regard are found in paragraphs. Averments and allegations are found. The allegations and averments are found in paragraph 7 in the petition. That quote paragraph 7, page 8. It was submitted on behalf of the petitioner that in this, but no student have come.
Not students, my lord, have not come, lord. I have mentioned that because students cannot approach, my lord, we have not taken up the cause.
It was submitted that the action on part of the officials of the respondent 3, Karnataka Examination Authority, who acted in the aforesaid way, tantamount to violation of rights under Article 21 capital. What is 21A? 21A,
Right to education, my lord.
21, 21 capital A, 25 and 29(2) of the Constitution. Full stop. It was further submitted that anybody complained to you?
My lord, there are FIRs filed, my lord. In Sagar, one FIR is filed.
It is stated.
My lord, subsequent to the filing of this petition, my lord, one FIR is lodged in
Stated
Sagar.
that subsequent to the filing of the petition
On 21st April 2025, my lord.
on 21st April 2024, the first information reports are also filed in certain cases. Full stop. Learned senior advocate for the petition submitted that the sacred thread worn by the students was done after ceremony called Yagnopavita, which is part of the essential religious cum cultural practice for the students, for the persons concerned. It is the case that the sacred threads were torn
Yes,
before
cut
the
and
students
disposed. They were cut, my lord, and disposed.
cut or forced to be removed before the students were permitted to enter the examination hall. Full stop. What further weighs? What really weighs? What weighs with the court is also the aspect that the averments are made in the petition that those students who refused to do so and obligor to remove the thread, they were not permitted to enter the examination room and they have been deprived of, is correct?
Yes.
Deprived of appearing in the examination. Full stop. The petitioner needs to further substantiate the above allegations. Full stop. Notice returnable on. Paragraph. When shall we get?
Anytime, lord.
9th of June.
Lord, I have sought, my lord, that they should possibly reconduct the CET for those, my lord, who have been deprived on this count.
There is no details are given so far. We have to give specific details that these are the students. Students are not aggrieved. So only because the allegations are there in the petition, we are issuing notice. But really, it requires further substantiation.
We will get more details, my lord,
At
and
least
file it.
in terms of the names of the students who
Yes.
are prevented, at least give some name, some
I
instances.
can file it.
Maybe
We will file
reflected
it
in
due
the
course.
FIR.
All three are government authorities, my lord.
That's correct, but then this, since allegations are serious, we have to be more careful also as a court.
Yes.
Now, those students, my lord, as what I have read from the newspapers, my lord, they have been offered seats in government colleges, my lord, and without they appearing for the exam, considering an average, my lord, in 2 subjects. My lord, it's painful for the government also. It wasn't done intentionally.
Normally, nobody would,
Yes.
Lord, it's
unless
very,
somebody.
Lord, what has happened, my lord, is it is not in one center that it has happened. It has happened in
So
different.
why should the officers do that?
I don't know, my lord, but it has happened. They have not taken any particular action.
No, action has been initiated, sir. I'll produce,
And
place
also,
the-
Lord, the KESS.
When queried, before notice, when queried as to why any officer should indulge into such practice, learned senior advocate for the petitioner could only submit that the incidents has happened at the centers and it has resulted into FIR. Full stop. Then further said that the allegations needs to be substantiated also. Then notice returnable.
Correct.
Obliged.
Green bench matters, seal number 10. Mr. Venkatesh Somareddy.
Please.
Notice returnable.
In one sentence, my lords, the government, my lord, by an amendment to the mines and minerals rules, my lords, introduced a new provision 3F. It said, as for the traditional quarry workers, they have the preference, my lords, not to this anything. And my lord, in the meanwhile, only one prayer, my lords. These persons have made a claim. Petition is filed. Their petition application is not considered, despite my lord's orders earlier, my lord, direction to them. They have granted it to respond number 6. We have preferred a revision petition. That has not been considered, kept pending. IA is also filed. My lords, about the grant made to them, my lords, pending consideration. If the grant order notification is made, further steps are not taken. If my lord, they take further steps and grant the very same land in which we belong to scheduled caste, we are eking our livelihood by traditional quarrying, my lords. My only prayer is pending consideration, my lord. Let them not take further steps pursuant to
My lord, parallel proceedings have been set in motion, as my learned senior himself has submitted that he filed a revision under Rule 53 on 13th March 2025.
Kept pending. They don't consider it since
Same
1.5 months.
Parallel proceedings.
That remedy is available.
Yes, my lord.
Yes, I
Annexure
have
G.
got that.
Please, Annexure G, my
No,
lord.
I have myself stated, my lords.
75.
My grievances may put it one
Annexure G.
sentence. Please, I have already availed the remedy, my lords. I availed the remedy, my lords. They availed the remedy and filed the application. Page 97. Application is also filed for.
Against this notification revision.
Yes.
Well,
Yes, my
revision
lord,
is filed.
and it is filed
Revision
on
is filed.
13th
Please.
March 2025.
My learned friend probably has not read. Revision is filed. Along with that, an application for stay is filed, my lords. They don't consider it and don't even give a date.
Where
Since
you
1.5 months, I have pleaded it, filed it, my lords. Page 75 is the revision filed on 13/3/2025. Page 75.
Where is your averment?
Averment in the petition, my lords. Please, my lords. In the
The
annexure.
same prayer which is sought
Annexure.
before my
See,
lord.
please,
sought
annexure
even before
G,
the
page
commissioner.
13, my lords, para 14. And an application is also filed for consideration of the interim prayer. They don't consider it. In the meanwhile, they proceed ahead, my lords. Revision is maintainable, my lords, against that. Para 14, my lords. Para 14. 13/3/2025. Repeatedly, learned advocates have gone there, requested, filed a memo, my lords, requesting to take up the case. No date is given, not taken up.
The reason
They
the
would
writ petition
usual
may not be
please,
maintainable.
usual modus operandi, my lords, keep the revision pending, render it infructuous. In the meanwhile, they will proceed ahead with the impugned notification, my lords, at annexure F. If my lord is pleased to direct them to take up the revision in a time-bound manner, my lords, and in the meanwhile, my lords, kindly be pleased to,
my lords. The
my
reason
lords,
being,
please,
my
let me
lords, I
complete, my
appear for
lord.
the KV term, my lords.
Let me complete, my lords.
The application has been rejected. That has not been brought before this court at all. Pursuant to the order of this court, the application has been rejected by the concerned authorities. Yes, my lords, we have the copies of this.
That's
before
exactly
us.
under challenge, my lords.
That is not under challenge. The order is stated 21/2025. That is not under challenge. Their rejection is not under challenge. My notification is under challenge, my lords, when they do not have a basic right.
May I also beg to draw my lord's kind consideration to amended rule 3F, my lords, is subsequently introduced in December 2024, my lords. It will come into effect from January 2nd, which clearly provides, my lords, that traditional workers have the preference. It cannot be granted to anybody else. Despite this, they proceed to pass the notification, my lords, granting it to respond number 6. Is so influential, very connected to one minister, my lords. Therefore, they keep our revision also keep pending. Nothing happens with the revision. Therefore, we are before this honorable court. We have no other remedy except to pray, my lords, to direct them, my lords, and see that our prayer is not rendered infructuous. till the consideration, my lords, or till the disposal of the revision. Let them not proceed ahead with the impugned notification, my lords, not take further steps. This is in gross violation of 3F, my lords. May pray, my lord, page 41, please, my lords. Is a new provision, my lords, to help the people who are downtrodden, who are entirely eking their livelihood on the mining, traditional mining. And Tashildar has notified, my lord, they are the traditional workers. Tashildar issued the notification.
Heard learned advocate,
That's,
Mr.
I'm on KV.
Please.
May I make one submission with
So
permission?
and so the petitioner, comma, learned additional government advocate, Srimati Neelofar Akbar, correspondent state and authorities, and learned advocate Mr. Mahesh Chaudhary, correspondent
6.
state pollution control board.
No, that's IPF for the private respondent.
Private response.
Private respondent.
Private response number,
Six, my lord.
Six, my lord.
full stop, preferred under Article 226 of paragraph, filed under Article 226 of the Constitution. In this petition, the challenge is sought to be raised against notification dated 27/1/25, whereby response 3 has granted mining license in favor of December 6. It is further read to direct the respondent number 1 to 5 authorities to consider the application of the petitioner dated 15/1/25 and grant mining license to the petitioner in respect of the property in question. The petitioner paragraph appears to have applied for grant of mining lease in respect of land property, which is a quarry situated in survey number 51/3 at measuring 5 acres at Vaderahalli village, Yagatti, YGATI, Hobli, Adur Taluka, Chikmagalur district. Post of. As the order was passed, dated on 27/25 in favor of the 106, the petition is filed. Full stop. There is no gainsaying that against the order of notification impugned in this
Annexure G, page 75, my lords.
petition. The petitioner has got alternative statutory remedy of preferring the revision application under Rule 15 of the Karnataka Minor Mineral Concession Rules,
Yeah.
Already filed, my lords, at Annexure G.
1994. Full stop. Not only that paragraph, the petitioner has already filed such revision application. Full stop. This is borne out from the averments. Averments.
Para 14, my lords.
Averments in the petition itself. Yes. 14, we have made in paragraph 14 of the petition. Paragraph 14, the said paragraph. In the said paragraph, it is stated as under. So this page 13, paragraph 14, bracketed portion. Paragraph. The revision application was filed recently on 13/3/25. The petitioner says that it is not being taken up. Full stop. It is the further grievance that this 106 is an influential person who is not allowing the revision authority to take up the proceedings of revision. Full stop. The court is not court is not inclined to accept such stand. Full stop. Such stand that such say of the petitioner that the authority is influenced by the private party. Full stop. When the petitioner has already availed alternative statutory remedy, this court is not inclined to exercise its extraordinary writ jurisdiction. Also, the petitioner has to pursue and exhaust the remedy of revision, which petitioner has already opted by filing revision. Full stop. While not entertaining the present petition on the said ground alone and without expressing an opinion on the merits, it is directed that respond number. Who is the revision authority?
My lord, he's not made a party.
Yaru?
The revision authority.
Revisional authority. Yaru? This is government alva.
He's not made
Shall,
Government, revisional authority, my lords.
shall take up the revision application filed by the petitioner, interpret copy of which figures at page 75 onwards in excerpt G paragraph. By fixing a date to hear the same and decide in accordance, strictly in accordance with law. Also, as regards the date, the revision authority shall give at least 15 days prior notice to the parties to appear. Full stop. The petition is dismissed subject to above limited observations.
Obliged.
May I make only humble submission, my lord. Till they decide it, let them not, my lords, continue with the NFRF, because we have prayed for a stay which is not taken up on 13/3, my lords. Since 13/3.
Since it's just one.
They are not taken up, my lord. In the meanwhile, they are proceeding with the notification. Now, my lords, notification, my lord, has not been effected till now. They are in the process, my lords. And that's offense rule 3F. It says we are entitled to preferential treatment, my lords. 3F clearly provides for. Only prayer is till they decide, my lord, that it not be rendered infructuous, my lords. And 3F with the language, my lord, used is.
It will be open for the petitioner to pray for interim relief in the revision proceedings by making separate application.
Application filed, my lord. Application already filed, maybe.
In accordance with law and on merits.
Application is already filed.
We are giving opportunity of hearing to all the parties.
Until then, my lord, they will now delay. IA cannot be considered without their appearance. They will delay it, my lords.
Till don't invite that observer.
Pardon me.
Then don't invite that observer. Last.
May I only pray, my lords, till it's decided, my lords, let not they only for within 15 days let them decide my IA, my lords. I have no other remedy, my lords, except to approach this one. They keep it pending for from 13/3 till now. Nothing has happened, my lords. And also one sentence, my lords. 3F amended provision strictly says it cannot be granted to anybody else except to the traditional worker. Tahsildar has given a report stating that we are traditional workers. The mandate is now clear, my notwithstanding anything contained in the rules, my lords. That is the exact words. And it should be granted to the traditional workers of comprising of scheduled castes and scheduled tribes, my lord. The preference is given. And if there is a overlap with their application, my lords, their application is liable to be dismissed. That's the word used, my lords. This is a new provision which has come into effect with effect of January 2nd of 2025, my lords.
Is there energy and argument for?
No, my lords, the energy will be rendered infructuous, my lords. That can only be utilized before, my lords. There, your lordships, they will see that it's rendered infructuous.
We are draining our energy. What
11, standing to Dana.
Grateful, my lords.
Yes, 11 is also yours.
No, not. I'm appearing for the petitioner in this matter.
Yes, what
I'm
is
seeking for deemed extension for a period of 2 years.
Notice written.
Please, ma'am.
My lord, it's a positive direction that has been sought by the
11th June.
Much of.
obliged.
So, writ appeal matters.
So 12, 13, 14,
12.
15,
12.
16, 17. All notice written. All delay.
14 lordships have set aside the office objection. There was a direction to
delay of 15 days.
On it was listed day before. Lord, your lordships have overruled the office objection.
No, delay. Delay in filing of it.
Delay.
Immediately on reopening.
Very well.
14th on 5th of June. The rest. So in 14 notice in delay and in appeal both. Returnable on 5th of June. In the rest of the appeals, notice returnable in delay application, returnable on 26th June.
Only in 16 maybe add on 4th June, my lords. Connected matters are coming up.
16th also 4th June.
Lord, for item 14, what date your lordships have? Item 14? What? 5th. Very good.
Similarly, 12 connected matters are on 27th June.
Which one?
Till number 12 connected matters are on 27th June.
12 connected coming up.
Yes.
When coming up?
I didn't hear you. Miss.
When it is?
It matters 27th June.
So 27 June. Rest whatever dates, 25, 20, all 26.
This is arbitration matter, seal number 18.
For the appellant in this case, my lords. Lords, we request for a passover to 2:30 today, my lords.
Last working day. Lord, I believe that 2:30 this combination may not be.
What is the matter?
Lord, it's a 37 appeal against concurrent findings by the tribunal and the section 34.
A date may be fixed sometime in the first week of June, my lords.
Date, second week of June, we'll say, not first week. Is that urgent? Is it urgent?
No, my lords, I have consented and an interim order is granted by consent. There's no urgency.
So 11th June.
Great.
This review petition
It is jointly requested by the parties. 10 or 11th June.
Seal number 19.
After vacation, my lords, there's a review petition pending.
After vacation. After vacation. Dates, gave some date in July. 14th, 15th July.
Very much.
Seal number 20. Siddhamalappa PM. Seal number 20, Mr. Siddhamalappa.
After vacation, 17 July.
Seal number 21, Mr. Basuraj. Mr. Basuraj. Mr. Saravana S.
July. 10th July.
Seal number 22.
Lords, this honorable court has, the matter has been disposed of by this honorable court on 7/4/2025, your lordship. Whereas at page number 10, para number 6.1, at line number 6 to 10, your lordship. The observation ought to have been typed, appeal came to be disposed of with a direction.
So appeal came to be dismissed, is to be substituted.
Yes.
Only. And second imperative.
And second prayer is in the same line, your lordship. The Tahsil Anekal Taluk, Bangalore was directed to effect mutate in the revenue records the Sarkari Gumal land in respect of the above expression of land, 1110/P. That has been instead of the Tahsildar Anekal Taluk, Bangalore here directed to effect mutate in the revenue record the name of the impeding applicant herein.
So that is correct.
Yes.
Herein.
I may be permitted to produce the AC order, your lordship.
So which observation to be rectified? 6.5. Order dated being passed in
5/6/2023.
Oh, in that. So only two corrections. Full stop the, shall do it, full stop the petition which was disposed of on 7/4/25 comes up along with memo for being spoken to. Full stop. Learned advocate for the petitioner. Impleading applicant.
Yes, in page number 11.
You're impleaded?
Yes. No, my impleading application is not allowed.
But for the impleaded respondent has pointed out that following errors of transcription have crept in comma in the aforementioned judgment dated 7/4/25. Then you this memo for 1 and 2. Full stop. In the above view, so learned advocate for the respondent,
Madam,
is so and so confirms that the above typographical errors are required to be corrected. Full stop. In the aforesaid view, comma, the corrections as prayed for above in 1 into bracket and 2 into bracket
And page number 11, para number 6.4.
shall be carried out as a registry and fresh order with and fresh order duly corrected accordingly shall be issued. The memo for being spoken to is allowed and disposed.
My lord, he hasn't been impleaded at all. His
I am
application for
not
impleading
impleaded. I am not impleaded, Your Lordship.
application for impleading was pending.
That I'm just clarification. The AC order has been disposed of with the direction to enter.
How can you file an application?
Yes, my lord, that was my argument. He wasn't in possession.
No, my land is available. So
Therefore, we asked whether you are impleaded.
no, I'm not impleaded. I'm not impleaded, Your Lordship. No, the finding of AC order is it is disposed of. That is dismissed.
Really up starting read petition which was disposed of. Read it. Has come upon board today upon a memo for being spoken to filed by Learned David for the impleading applicant. Full stop. The applicant who has filed this memo for being spoken to, comma, when asked, comma, Learned Advocate submitted that he was never impleaded in the proceedings of the petition. In that view, comma, the person was not party. The applicant was not party to the person who was not a party to the proceedings cannot move the memo for being spoken to. On this ground alone, the memo of being spoken to is not entertained, comma, if the corrections are required at the
Lordship.
At the corrections, not at any other party to the proceedings.
No, my request is, Your Lordship.
Any other party to the proceedings of the writ petition is at liberty to move the memo for being spoken to if advised.
My request is, Lordship, the AC order is allowed in my favor. That is this typed as dismissed. That is only my concern.
So, sir, you ask somebody, your friend, to move the memo. We have said that.
Cell number 23.
Withdrawal.
Withdrawal.
My lord, I am the party in person of the petitioner. My lord, I am the petitioner, my lord. The memo for withdrawal is filed for the PIL, my lord. The matter is settled before the office of Labour Commissioner Davangade, my lord. Therefore, my lord, seeking dismissal.
The petitioner party in person appears to video conference and states that he wants to withdraw the petition. Further stating that the memo of withdrawal is filed. Also, the party in person is directed to appear physically and make such request. Stand on 12th of June.
Please,
This is cell number 24. So furnishing of process fee, etc.
We shall do so, my lords. 4 weeks time.
4 weeks time is granted to learned additional government advocate for the state, appellant state to take necessary steps.
So, office objection with council submission, cell number 25. Mr. Venkatesh Sarabati.
Regarding Kannada translation documents, that subsequent development is there. I will file. I am seeking dispensation only for the reason that I will not rely upon any of the those. Only impugned order. Impugned order is not a writ petition filed by us. The Karnataka Lokayukta is dismissed on the ground of locus.
The translation of Kannada documents 25 is dispensed with, subject to condition that if in course of the hearing,
yes,
translated copy of any of the documents required, the same shall be supplied by the types. Bill may be listed on 17th June.
Cell number 26. Mr. Ashok Narayan Naik.
I appear for the aviator, my lord, in this case. The Learned Single Judge has only remitted the matter back to the land acquisition officer with a direction to give notice to the respondents, private respondent, and redo the matter in respect of 2 survey numbers which were converted from agricultural purpose to non-agricultural purposes. He has not expressed any opinion.
Okay, delay is there. Delay of 126 days.
My lord, in this matter,
There is a delay of 126
Yes,
days.
ma'am.
Notice returnable on.
my lord, the council appearing for the
The office objection regarding color photograph is dismissed. There shall be notice in the delay condonation application returnable on 26th of June.
And I'm permitted to take notice the counsel appearing before
addition
the
to the
learned single judge.
in addition to the normal mode of service, learned advocate for the appellant is permitted to serve copy of the appeal and the application to the counsel who appeared before learned single judge.
Number 27, Mr. Sudhakar GV.
The fourth respondent was a party before the single bench, my lord. Page number 26, it was a party. In the final order, the name of the fourth respondent is not forthcoming. Therefore, I made a party in the appeal.
He was a party.
He was a party.
Learned advocate for the appellant states that respondent 4 was a party in the original proceedings. However, in the title of the judgment, by inadvertence, it was not reflected. This office of resistance is accordingly dispensed with. Full stop. There shall be notice in the delay application returnable on 4th July.
It's number 28, Mr. Sharath Gowda GV. Number 28.
Office objections regarding color photographs is dispensed with. The appeal may be listed. Sorry, there shall be notice in the interim in the application for delay returnable on 18th July. Full stop. Learned advocate for the applicant appellant is not present. Next.
Number 29.
Serial number 29, appear for the appellant. My lords, this is a challenge by the respondent, my lords, against an interim order passed by the learned single judge. Learned single judge permits the petitioners to file a complaint before the jurisdictional police in a case, my lords, where the allegation is whether the documents have been lost or not. Now, my lords would kindly notice the impugned order, my lords, page 24, my lords. By virtue of this, my lords, though the HR department was in charge of this entire recruitment in the year 2015, now notice is being issued to the managing director of Canara Bank to appear before the investigating officer to ascertain whether the files are there or not, my lords. My lords, page 24.
Or so nothing doing. We are dispensing it.
My lords, but managing director, my lords, HR department concerned people.
You go before learned single judge.
No, my lords, one aspect, could I just point out, my lords? The entire case in the writ petition is not.
Go before the police and help in the investigation.
Not investigation. This is an inquiry being done by them to the concerned, my lords. If they send notices to the concerned manager, senior manager, they will be able to explain it. Managing director is being.
Go to learned single judge and file review application.
I'm sorry.
File review, seek review of this.
Please, my lords. Please, my lords, if I'm permitted to file and review at least on that order, because managing director can't be summoned in a matter of this nature, my lords.
We do not. Course of learned advocate, you are withdrawing to file review.
Please, my lords, we'll withdraw and file a review.
Course of the hearing of the present appeal, learned advocate, senior advocate, Mr.
I'm sorry, my lords.
For the appellant bank, having realized that the order impugned in the appeal is interim order and that the proceedings of the writ petitions is pending at large on merits, sought permission to withdraw the petition, stating that the appellant bank would prefer to seek review of the order, said order dated 7th April 2025. Since the submission is that the managing director is not required to be subjected to police investigation. Full stop. Without expressing any opinion on the said aspect, the petition is permitted to withdraw, appeal is permitted to withdraw with liberty to the appellant to file a review petition.
Please, my lords, please.
In respect to which, however, this court does not express any opinion on merits.
Please.